Welcome, I'm Jon Caldara, president of the Independence Institute and your devil's advocate. A little later on in the program, we're going to be talking RTD and a tax increase you don't even get to vote for. But first, the governor granted clemency. No, he didn't grant clemency. He didn't have. What the hell did he do? District Attorney from Arapahoe County, George Brauchler, thank you for being here.
Thanks for having me. I appreciate it.
This Nathan Dunlap punt, that's all this was that the governor did, I'm still trying to make sense of. So explain to me, he had the decision of either to sign the execution order for this mass murderer or to grant clemency, which meant that he would, a final decision, and he would never be put to death. Do I have that right? That was the decision. But what did he decide? I still don't quite understand.
Sort of. There's a misconception that the governor has to sign some sort of a death warrant or an order. He does not.
Really?
No, everything's been put in place. The only thing the governor has to do is allow the Department of Corrections to put itself in a position to carry out what is now going to be the order of the court based upon the judgment of that 12-person jury from 1996. He doesn't have to sign any other special order.
Let's take Nathan Dunlap off the table for just a second. Someone is coming up on a death penalty. It's gone through the million different reviews. It went through the judges. What is the role of the governor at that time legally? Does he have to take an affirmative action in order for the execution to take place? Or if he just says nothing, it takes place? Which way is it?
He says nothing and it has to take place, but this particular governor wanted to interpret his position as, instead of being someone on the sidelines who had the constitutional authority to interject himself into it, he viewed himself as an active participant in the process because the Department of Corrections employees who work for him had to take certain steps to put themselves in a position to execute the order.
That's fascinating because I had it all wrong then. I thought by law that the governor was the final check and balance, that he had to take some sort of action in order for the death penalty to be carried out. In fact, he would have to take an action to stop it.
That's correct.
I have that right.
That's
all
correct.
Right. And he did kind of sort of maybe stop it. I thought he would grant clemency. It looked to me like he was giving all the signals. It looked like he was getting pressured by people inside his administration, and that clemency was going to come down. Were you surprised by his punting of this issue?
I was surprised. I too had convinced myself, based on all the things you've talked about, conversations I'd had with him face to face and other people in his cabinet and others around him, that he was going to grant clemency. And that's one of the constitutional powers afforded him, as well as a pardon and this reprieve power. But what's interesting is this reprieve power, at least based on our research, has not been used since the 19th century by any governor. And the last time it was used in the 1890s, it was used for a temporary suspension of the death penalty while an issue that had prior to that not been brought up was investigated. And once
1890.
1890 was the last time we could find it being used.
If I understand this, he has said, I'm not giving him clemency, but I'm not letting the death penalty go forward. I'm just putting this executive order in, a reprieve, and I could change it anytime in the future, but I won't. That means a future governor could change this. If you're someone who supports a ban on the death penalty, is this a celebration?
I think it depends. I think if you're one of Dunlap's defenders, you look at any day above ground as a win for you, and that's been your course for the last 20 years, is to try to keep him from having delay. So this is good. If you're someone that is an advocate of no death penalty or clemency, I'm not sure how you feel about this. I think you anticipated the governor would send a much stronger message to the state of Colorado and to prosecutors like me about the position of the executive on this. Instead, it was much more like a shrug or a punt, which was, I don't really know what to do. I mean, the concerning thing for me as a citizen, not just a district attorney, is that this constitutional power available to him, in my opinion, has been abused. A pardon, clemency, or a reprieve are things that should be case specific. There should be specific factors about an individual's case that the governor would intervene to alter the course of. But instead, if you read that executive order, he spends much of the first paragraph condemning Nathan Dunlap and his conduct, but then condemning the death penalty statute and saying, I'm going to exercise this constitutional authority, not on an individual case, but on an entire law.
So in other words, the gov said, I didn't find extra evidence that wasn't considered. I didn't find a little something that wasn't brought forward, and thus gives me reason. basically he said, you know what? I don't think I like the death penalty. There's no doubt that this man is guilty. There's no doubt the witnesses were there. He admitted it. He's remorseful for it. There's no question about it. So this was not a statement about Nathan Dunlap. It wasn't saying, well, you know, he was mentally ill. It was just saying, I don't like the death penalty now, so I can't pull the trigger.
Yeah, that's absolutely right. In fact, if you read that executive order, he cites things like foreign countries, the European Union,
right,
world religions, things that have really no business in Colorado's analysis of Colorado laws by a Colorado governor. It doesn't make any sense to me that if someone is opposed to a law that they feel like they're empowered, especially as governor, to say, I'm just not going to enforce that law. Best example I'd give you is these Second Amendment laws that we've had passed, these gun laws. Could the next governor, adopting a page out of Governor Hickenlooper's book, show up and say, you know what, I'm not convinced these things add to public safety. I'm not sure they're a benefit. I think they may be a violation of the Constitution. So therefore, I'm going to grant a temporary reprieve to everybody who's been or being prosecuted for violations of these laws until either the state catches up to my way of thinking, or the next governor may want to impose penalties on those. Could they do that? Because it's the exact same theory. I disagree with the law, therefore I'm going to suspend its execution.
The next governor can change this executive order.
Yes.
He would have to take an affirmative action. He'd have to do something and take away this order, or the governor after him, or the governor after him.
That's correct.
Or the governor after him. So at this point, there is still, there's still a guillotine over Dunlap's head, and it's just being held in place by this executive order that could be taken out any time in the future.
Yeah, that's true. There's some still pending motions that were going to be litigated prior to the governor's action here. I still think they're going to be litigated. We're advocating that we push through those issues so that when a governor who's capable of making a decision comes in and makes one, there's no more legal ramifications or wrangling. But you should anticipate this too. Because the fact that a death penalty week was set in August, and now we've sort of suspended it for some unknown period of time, the defense will now, in my opinion, at some point later, raise the issue of whether or not this was a violation of the Eighth Amendment. This was cruel and unusual to have told a man, you're going to die on the week of August the 18th, and then to pull it back, and then maybe 2 years later then reimpose it. So not that that's a winning argument, but the governor's created that argument. Here's something else that people don't know. The governor's action has already shown up in defense motions filed in federal cases, death penalty cases, right here in Colorado. Our U.S. Attorney's Office is seeking the death penalty on 2 inmate murders of other inmates, not even guards, other inmates. And those defense attorneys have already started filing motions citing the governor's reprieve here as, in essence, a moratorium on the death penalty that ought to be factored in as to whether or not it is cruel and unusual.
Let me ask some of the specifics. I've heard that Nathan Dunlap had manic personality, he had bipolar, or he was manic depressive. That stuff didn't come out in his trial. Therefore, he shouldn't be put to death.
Nonsense.
Why?
Utter nonsense. First off, his first approach to try to beat responsibility for his conduct was to claim incompetency, which is the first stop on that train. Well, he was sent down to the state hospital, and those doctors came back after a prolonged period of examination and observation and said Nathan Dunlap was a malingerer, a faker. And so his defense team, who had knowledge of these particular other mental issues, made a strategic, a tactical decision, if you will, to not introduce these mental health issues in because they knew it would open the door to the prosecution then being able to bring out these state doctors to go, he's a faker. He is not suffering from some sort of mental disease or defect. So the fact that it took until 2006 for the defense to find a doctor or two who would say he was bipolar doesn't change anything. It was a strategic, tactical decision at trial by his defense team, an expert defense team. But more than that, no doctor has said, and no judge has found, and they've considered the bipolar thing for years now, no one has found that his conduct back in December of 1993 was the product of any bipolar, manic, or depressive disorder or any other mental illness. And if you watch his statements in 1996 after his conviction, what you see is a cold-blooded killer. You don't see someone suffering from manic statement or a depressive state. He is a cold-blooded killer. He's an evil man.
Let me ask you about the oddity that is Arapahoe County when it comes to the death penalty. There are 3 people on death row, if I've got it right, all from Arapahoe County, all that are African American, and a couple of them, I think, even from the same high school.
They're all from the same high school.
They're all from the same high school. So can't someone reasonably look at that and go, wait a second, the odds of that happening are pretty high. There's obviously some sort of bias in Arapahoe County that pushes this at an unfair level. And I know you're relatively new to this job, but it's Arapahoe County. That's the place you don't want to commit a crime.
Well, I agree. That is not the place you want to commit a crime. But no one reasonably could conclude that, but they could superficially conclude that just based off of the statistics you brought up. 3 guys on death row, all from the same high school in Arapahoe County. Therefore, it must be Arapahoe
all black.
County. They all are African American, but that is a function of a statistical anomaly, a historic anomaly. Because if you look at the 20-year period of time prior to now, and think about it, these two cases with these guys took place 12 years apart. Sir Mario Owens and Robert Ray, who murdered Rhonda Field's son and fiance because they were witnesses to another murder, and Dunlap, 93, 2005. But if you look at the full 20-year, 25-year, go back to 1976 when the death penalty was reinstated as a constitutional punishment. What you see is there are, I think it's 7 jurisdictions in the state of Colorado, even more than just the metro area, who have sought the death penalty numerous times. But whether it's juries coming back and not imposing death, whether it was because of errors related to Ring versus Arizona saying that a 3-judge panel could not impose death, or some people dying in between conviction and death like Albert Petrosky, what you see is over that period of time, the death penalty has been sought in a number of jurisdictions, predominantly on white males. And out of the 3 biggest groups, white males, Latinos, and African American men make up the smallest group of cases for which death has been sought.
Let me ask you this part. It seems as though the death penalty in Colorado is very, very selective, that whether you get the death penalty or whether you don't depends on all sorts of weird factors that don't seem to have a whole lot of consistency. The last death penalty that was carried out was what, 10 years ago?
1997.
1997. So it has been, and Roy Romer was governor at that point.
And it was a white guy out of Adams County that got put to death.
All right. But it's so rarely used. Is it so selective that there's no consistency, thus making it very unusual? If it's cruel and unusual, can't we say in Colorado the death penalty is at least unusual?
No, I think we could say it is rare, but not in the unusual sense that the 8th Amendment prescribes. Instead, every case that's prosecuted across this state in our 22 judicial districts is prosecuted differently by prosecutors who are elected to represent their communities. It should come as no shock to anyone that even prior to the legalization of marijuana, that Boulder took a far different approach to the prosecution of drug cases than, say, El Paso County or Douglas County. That's not the function of any arbitrariness or randomness or making anything unusual. That's the function of elected prosecutors representing the communities they have to answer to and the communities they live in. And the same is true of the death penalty. It should be rare. We're not Texas, we're not Kentucky, we're not Georgia.
How much has been spent on this 20-year process on Nathan Dunlap?
I don't know that anybody knows the true number, and I know that there have been different studies out there that try to suck in a whole bunch of extra costs, calculated this, that, and the other. I don't really know the answer.
Let me ask you this one, final question.
Yeah.
I hate to use the word closure, but on both sides, people who are defending this mass murderer and people who are the family and loved ones of victims, that August death penalty brought an end to this one way or another. What happens to them? What happens to the families at this point? Where are they?
They're in a limbo/purgatory that I don't think anybody can truly understand and don't want to understand. I mean, the governor, in calling them together on this day to let them know that he was unwilling or incapable of making a decision about this, really pulled off a scab from a sucking chest wound that they've been dealing with for 20 years. And then he sent them out without really any hope that it was going to be resolved in the near future. I don't know how these people get together. I don't know how they go to sleep at night anymore feeling like we thought we would know an answer, if not the answer we wanted, an answer, and we could move on. Because whether it's this year or next year, and you got to know this too, the governor has intentionally made this a campaign issue. Nathan Dunlap's life, in a large extent, rests upon the re-election of Jon Hickenlooper. What an ominous thing to have created for your re-election, to become the guardian angel or defender of one of the biggest mass murders in the state's history and make that a political issue instead of an issue of justice.
George, thank you for being with us.
Thanks for having me.
Stay tuned. You're going to want to hear this one.